But he still has instructions, Mr. Chairman.
All of you cannot proceed.
I think it is very important what the judge advocate is giving us advice to this court. And I will here now declare that I've been a judicial officer of the rank of senior resident magistrate. And even in contempt proceedings, you cannot sentence an accused in their absence. You must put the contempt to them. So we are saying that procedure in this court will be very important, and it is of utmost fundamental importance, the advice given. And when we object to the advice given, it is important that the court, in accordance with the rules of procedure, pronounces itself. You are at liberty to side with the judge advocate, or for good reason to differ with him, because we are objecting also based on law, so that you are given the correct procedure. What happened to Aaron first happened, and he is going to take action accordingly. But if moving forward, the proper procedure is not applied, then we are at risk. That's what we are saying.
I think so. Mr. Chairman, close the chapter. Those matters are.
When we are closing the chapter, but what I want to hear the first argument that just feel free unless you conduct yourself in a manner that is befitting you. This business of making noise, stand up, we go, we do what, that one is not going to be allowed. You do that, you are held responsible. Let us conduct ourselves the way we are supposed to conduct ourselves. We listen to each other and we proceed.
Mr. Chairman, allow me the latitude, Mr. Chairman. On the issue of, yes, much obliged, Mr. Chairman. On the issue of changing the panel, Mr. Chairman, it has far-reaching consequences. For instance, when at the ruling which resulted in sentencing, my land friend Aaron Kiza was being read, reference was made to his earlier conduct in 2024. But Colonel Okalepo was not present in 2024. However, he participated in sentencing Aaron Kiza. It has far-reaching consequences, Mr. Chairman. Indeed, something must be done. I thank you.
Before you thank
I think they need to give them the other instrument of ours so that they understand this colleague.
Yes, sir. Whoever wants, whoever wants. And they are also advocates. They are there, they are subject, not just thinking that tracks. The one next, they are also advocates. The manager or registry is also under my office. So you can ask anything if you have an instrument to appointment.
Mr. Chairman, just the last one, the very last one, and it touches me personally. Mr. Chairman, it touches me. Mr. Chairman, it touches me. Mr. Chairman, I beg, Mr. Chairman, for your indulgence, Mr. Chairman. I thank you. Yeah, this is the very last one, Mr. Chairman, which you raised in your communication, Mr. Chairman. Mr. Chairman, if I may be permitted, Mr. Chairman. Mr. Chairman, I beg for your indulgence. No, I am seeking for the indulgence of the chairman. It's a humble, I know, and
this is what we are saying now. Because if you are to conduct ourselves like that, then we may not go anywhere.
Because, Mr. Chairman, we are dealing with matters of life and death.
We started, we are talking, you know.
Yeah, Mr. Chairman, it all depends on the gravity of the matters you are dealing with. The sentence we are talking about here is death. On the charges is death.
I suggest to read the rules of our court, respect to the chair and court. Who are not speak at the same time when you are standing. Sir, yes.
I listen to ruling on whether they amend on whether to amend the charge sheet or not. This court, after listening to the application by the council and the council for the state, amended the charges against the accused person by adding another suspect, and the objections, the amendment raised by the non-councils for the accused persons. And the court has considered the submission to the court council and the relevant laws relating to the amendment of charges as deliberated on the application and pronounced itself as follows. 1. That the amendment can be made in the course of the proceedings at any stage as long as no injustice will be caused to the accused persons. 2. That the hearing of this case has not started and no injustice will be occasioned to the accused persons. 3. In the premises of this court hereby allows the application amend the charges as read by the council for the state. So court clerk, you can take note the accused persons through the usual procedures.
The language of court is English. Each of you is going to tell court the language is going to use. I'm starting with you and the Besigye. Which language?
Mr. Chairman, we kindly request that we are availed a copy of the
Charge sheet.
charge sheet which is amended. Because once there have been amendments which court has allowed, ideally the officer preparing the charge and the court should sign is a complete charge sheet which they then respond. That is the one. Then we start the procedure according to the engagement. We do not have that copy. And also, Mr. Chairman, ordinarily when it's supposed to be done, because the accused person is entitled to advice from their counsel at that stage. We may advise them from what we see, and they say we are guilty. It saves time. The import is that so that we know what is coming, so that they are advised before they take plea. We kindly request, because we haven't seen the amendment, we don't know that it's there. And from what I can see, from being long-sighted, I think my colleague, the court official, is reading a table, not the amended charge sheet. We kindly request that it's given to us.
Because it will be ready, but the court clerk, I think, is doing another thing, not reading the charge sheet.
I'm proceeding. And Besigye, the language of court.
Yes, Mr. Chairman.
English, sir. Afandola. Which language? English. Afandola, English. Which language?
Get number 2.
In army, a soldier must follow his fellow soldier. English, are university, and the lawyers are known. Lastly, this is the panel of the judges who will hear your case. Look at them carefully. If you have any objection with any of the members, you will say so. But if you tell what is the reason why, I'm starting with you, Father Besigye. If you have any objection with any of the members?
I don't know who the members are.
Read the names.
Yeah, I know who they are before I raise an objection otherwise.
They are here, look at them. They are here.
Their names. Mr. Chairman, this may go to the issue of names, ranks, introducing the panel. Really, I do think that is where we are. Because you can't just say, look at them. What if you don't know someone? The requirement is actually to the names be read out and all that.
And we have been informed that the panel is beyond the ones who are sitting here. So we need to know who all of them are.
The 19.
We can provide the list of your panel to your
I think now you can start, you say, General Freeman Mugabe chairman, and all other members. If we have reserve, then also introduce themselves.
Is that what is they are talking about?
Yes.
That's what we do.
Brigadier General Robert Freeman Mugabe, Chairman of the Commission.
Major Richard Trialwe, Captain Abdar Sajara, member. Warrant Officer 1, Single Robert Nyarari, member.
Major Sana Sonko, member.
Lieutenant Colonel Sam Pungora, political commissar, member.
Captain Marion Akandenda, member.
So, we have the
Does the court have more members than have been introduced?
Yeah.
Because if they do, we want to know all the members of the court, whether they are here or whether they are not here, so that we can object or not object, since they are interchangeable.
That's right, Colonel. Colonel Ogarepo, who have not seen him today, and there is Captain McCowan.
The members of the panel, as duly established there, those the two regards, will not change because our clients are objecting or not objecting to the ones who have been introduced. The request that is made that will be a constant fact.
Exactly, that is how it will be.
Right?
Yes, Council Yeah, I have heard that. Yes, it will be like that. Yes.
That you have found it. Do you have any objection of any of the members and reserved members who have introduced themselves? No. Has no objection. A1, sir. Obey the retired. Do you have any objection to the members who have introduced themselves to you?
No.
The retired has no objection to the panel.
The General Court Martial holding at Martin, Kampala. Criminal case number UPDF stroke TCM stroke 040 of 2024. Dated today. Amended charge sheet. Uganda versus A1 RO12743 Captain Dennis Ora, male adult Ugandan of sound mind, age 48 years. Mr. Officer attached to Hamad Brigade, a person subject to Nijero. A2 ROV 0098, Colonel Judge Dr. Chiza Besigye, male adult Ugandan of sound mind, aged 67 years, resident of Kasangat Town, Nangabo Sub-County, Lansana Municipality of the District, a person subject to Nijero, by virtue of Section 117, subsection 1G, and H, Act, Cap 330. A3 Hatch, Ugaid retired, male adult Ugandan of sound mind, aged 65 years, resident of Mutundu Parish, Makindi Sabagabo, Sub-County, Siro County, Oxford District, a person subject to Mitero, by virtue of Section 117, subsection 1G and H, I of the UPDF Act, Cap 330. A statement of offense on count 1. Offense is relating to security and control, section 128, subsection 1F, the UPDF Act, Cap 330. Particulars of offense. Captain Dennis Ora, Colonel retired Dr. Chiza Besigye, and had obeyed retired between February 2023 and November 2024, while in the cities to wit Geneva in Switzerland, Athens in Greece, Nairobi in Kenya, and in diverse places of Kampala metropolitan in Uganda, held meetings aimed at soliciting logistical support and identifying military targets in Uganda with intent to reduce the security of the defense forces. Captain Dennis Ora, have you heard and understood the charge read to you on count 1?
Yes, I have understood.
You accept or you don't accept?
Madam Chairman, I seek your indulgence first on how to proceed. I've just gotten instructions at the bar to represent Captain Ola. I'm only privy to the amendment now. I humbly request that I interact with him and guide him. Thereafter, I shall formalize the instructions, if you please.
How long do you take?
Just a few minutes. About 2 minutes. Much obliged.
Once again, Captain Dennis Ora, have you heard and understood the charge read to you on count 1?
Yes, I've understood.
You accept, you don't accept?
I don't accept. I don't accept.
A plea of not guilty entered. Colonel retired Dr. Chiza Besigye, have you heard and understood the charge read to you on count 1?
I have heard and I have issues with the charges which my lawyers present to it.
I think
will address when time comes.
Mr. Chairman, we have objection to plea taking grounded on Regulation 23 of the regulations of this court martial, particularly sub-regulation 1, that before pleading to the charge, the accused may offer a plea to the jurisdiction of the court before taking a plea. The accused may raise the question of jurisdiction. Mr. Chairman, is on record. We have already raised issues to do with the territorial jurisdiction of this honorable court. And there is a ruling which is pending before this honorable court, which is not delivered. That this honorable court has got no jurisdiction to entertain matters which are alleged to have been committed in Athens, in Switzerland, in Kenya. We have raised that issue before you, and this honorable court martial has not pronounced itself on the matter. So it will be a violation of Regulation 23 for the accused person to proceed and make a plea before the ruling is delivered.
Are you not taking us, Council Court? Are you not taking us back? It is pre-taking. You can say yes or no, and then we can start from there.
Mr. Chairman, the rule is before pleading to the charge, the accused may offer a plea to the jurisdiction. That is the rule, and this is what I'm quoting. And oftentimes this court martial has reminded us to abide by these rules, and the judge advocate is so passionate about these regulations. I hope this time round is going to appropriate advice for this honorable court martial, that it's within the accused's right not to take a plea until the ruling is delivered from the jurisdiction.
You wanted to say something?
I'm reminding the Council of Kwabo that the accused himself raised that objection. I'm the one talking. No, you cannot object when I'm talking.
Can you listen and he finishes what he's saying?
You have not raised anything.
You have not even what that is saying. Now what are you objecting without even listening to what he's saying?
I can confidently tell this court and those who are present that the matter was raised and the court ruled on the matter. Registrar, can you avail the ruling that was raised objecting to jurisdiction by this court? Just to remind you, you read the ruling and when it was delivered. I will proceed.
Please, hold on and you wait for the registrar to read the ruling. That one will not stop you from submitting on what you want to submit. But first listen.
My Lord, with your permission, I proceed with the ruling by Public of Uganda, the General Court Martial, Ordinary Makinde, criminal case number DCM 040-24. Uganda, represented by the prosecutor versus A1, ROV 0098, Colonel retired Dr. Kiza Besigye. A2, Hajo Beti Mutale, accused persons. Ruling on application made by Council Elias Kwako.
Ruling raised on the jurisdiction of the court. Not the one of Rupaku. The one of Rupaku is not yet ready.
We are also interested in that one. If it is ready, we have been asking for it since morning.
I think if you don't have it, either you go to consult your files. I know that this was.
Why are you standing, all of you? No, sit council. First sit. Get that ruling registrar so that we don't waste, we have taken time. That ruling is there.
Volume of 14 year regulation. Agamba before. Hello? Hi. Why? I'm not away. Are you okay? But they carry come forward.
Why do you insist to want it now? When the court wanted to read it, you didn't want it. Now we are on pre-taking and the church wanted to do it. The procedure is that.
They say here they have it in their files.
I think, sir, for me, as judge advocate of this court, the registry is even under my office, and I am reading it is here. I have not written it now. So the ruling was pronounced by court. It is the accused who raised it himself on day one. So it shouldn't be a point of saying that you are raising it now. What you will do?
Charges. He added other charges. He has a right.
Oh, possibly.
My Lord, on 20th November 2024, day one, by then was retired Colonel Besigye. He objected to all the court members.
Yeah, I fail to understand. Do you think he's reading what is not written? I thought you were supposed to do the analysis.
He objected to all the court panel and jurisdiction. Even A2, who is now A3, raised the same objection. J guided that the accused have to give reasons for the objections as regards court's panel and jurisdiction. A1 stated that it's a military court and I'm not a member of military. I believe I should be tried by civilian court. A2 stated the same. JA guided that state had to give a reply to the objections. State replied as follows. It has for my word. It captures the concerns on jurisdiction.
It's helpful.
The ruling had a background. States have admitted that the object is one, the objection is one, and the reply
they stated as follows: that the enabling law, which is section 117, applies to all the accused persons, that is A1 and A2.
Those are different issues now. Because for me, I've always supported. And what I have is that what a judge is ruling on the objection, court came and gave the rulings, and I have ruling here. The court said they are subject to military law under section 117G and H of the UPDF Act. That was the ruling of court.
Mr. Chairman, the judge advocate by law is not a record keeper. He cannot assume the role of the registrar with respect, and therefore the registrar, it's under your office, but you cannot, the law does not allow you to come to court and be an advisor as well as a record keeper.
I'm the one who's commenting the law.
Mr. Chairman.
My lord, the ruling referred is that after 5 minutes deliberation.
Mr. Chairman, with your permission, if I may just correct my friend from the registry. When we were here last week, court adjourned the handing down of the ruling so that we could consult the accused persons who were two at the time regarding the instructions of counsel to receive the ruling. It might be recalled, Mr. Chairman, that when court asked for to assist in calling Mr. why there should be an adjournment, we did point out that we who were present, myself and Mr. Katumba, in the absence of Mr. Kalibala, who were counsel on the record at the time, were not in court when those objections were made. When we returned, the court adjourned to today without delivering the ruling and moved on to determine the matter of Mr. Aaron Kisa. So there was no handing down of the ruling. Now, my concern as counsel for the accused persons is that we understand that it should be the court to hand down the ruling. I think that is a grave concern which we need for the sanctity of these proceedings to remind ourselves the role of the court and our land colleague, the judge advocate. Otherwise, it is not a little, it is of much concern, Mr. Chairman, when the registry, which should be the central collection of proceedings for the day, appears to have no ruling. The court, led by your leadership, Mr. Chairman, does not recall reading or has no ruling, and yet the advisor of the court insists that for him he has no ruling. It is, again, Mr. Chairman, we need to remind ourselves that we, as lawyers, may understand the omissions, but to someone who is in the dock, who is a businessman, a doctor, a gallant soldier, who doesn't understand these proceedings, might think that this is a prearranged session. It is a little concern, and again, we wouldn't want because we do it at time. Sometimes, rather than doing what you're going through, perhaps the court to retreat a little, just to put his house in order, because now we are pulling rope and it doesn't appear quite nice, Mr. Chairman. It's my plea and my request, Mr. Chairman.
My lord and members, make it clear. On the first day, the accused persons were not represented, and that's when he has the objection of jurisdiction. And on the same day also, Lord Mayor, as then was now is in council, also raised objections. So there were two rulings. One was given, another one was pending. So the one that I'm reading today was giving the background what happened in court, and then another one you have given also. So I agree to proceed with the one on jurisdiction that was raised by accused persons at the time who were not represented. Citing section while citing section 117 of the UPDF Act Cap 330, court ruled that this honorable court had jurisdiction and has jurisdiction over the accused persons since they are all subject to military law by virtue of the same section. And ended there. And he proceeded and read the charges the accused person, to which they all pleaded not guilty. And then that's when Rukwago Elias, with respect, no, my name was not cancelled, had no instructions, proceeded and also raised some objections as pertaining to the charges. That's what we have.
You've been stripped of your.
I think I will be getting. Yes. The one of registrar, why are you saying that?
That one was finished, let us proceed.
Mr. Chairman, with your permission.
I was asking the panel that have you had understood the judgment to number?
I have heard and I have responded that I have objections taking plea on this charge and requested my lawyers to present my objections.
You are right, but at this moment I'm asking you that to the person, if you don't accept, you say I don't accept. If you accept, you say yes, I accept.
Accept what?
There are two things. If you have had understood, another question is, do you accept or you don't accept?
Accept what?
Maybe be of help to you, Mr.
Do I
Chairman.
plead guilty or not guilty? Or you want me to take plea?
He has invoked Rule 23 that he is objecting to taking plea.
Yes.
And therefore it may not be fair to ask him whether he accepts when he clearly invokes Rule 23 and it allows him to do what he is doing. So maybe you could allow, on his behalf, Counsel Elias Lukwago to raise the objections on his behalf as he has asked us to do, instructed us to do.
The registrar has read. It's the same objection that was overruled. So we cannot go back where we started before.
Mr. Chairman.
This is a new charge.
Mr. Chairman.
Please, no, I'm not because now you are taking us back.
It's a new charge.
It is, yes, it is a new charge.
It's a new charge.
Now, what if just now the one you are pushing for is corrected? Will he accept or he will not accept?
Mr. Chairman, if I may.
So the issue is we have read the charge. It is the accused person to bring guilty or not to bring guilty and anything that is not there.
Mr. Chairman, with your permission, humbly, Mr. Chairman. Thank you very much, Mr. Chair. Mr. Chairman, my learned friend, the JA, rightly pointed to the court adopting rules of amendment for criminal charges, and also pointed out to any amendment which can be done, which doesn't prejudice the accused person.
It's not right.
That is correct, and it's on that basis that the court made a ruling regarding the amendment. My colleague will agree that once an amendment has been made, the process which was running before comes to an end and starts afresh with the new amendment. The charges we have now, clearly, from looking at the amended charge dated today and the one before, are distinct. So essentially what the prosecutor has done is to start again the process which started in November. So the objections which were made then, if any, cannot be carried on by infection to the current charge sheet. To the extent that the accused person has seen and has new objections, because this is now a fresh charge sheet, Mr. Chairman, as the JA will agree with me, they are entitled to make the objections. They might be boring, they might be the same, they might be repetitive, but in a dispensation when we are saying it is his right, it is his right to make the objection. What we request is for court to listen kindly, and then also, as my non-friend has advised, and the JA, if we read together Regulation 23, kindly. Before reading to the judge, the accused person may offer a plea to the jurisdiction. And if he does so, the accused person may adduce evidence in support of the plea, and the prosecutor may adduce evidence in answer to that evidence, and the prosecutor may address the court in answer to the plea, and the accused may reply. Mr. Chairman, Regulation 23(1) applies before taking the plea. It is not even saying at the time, it says before. It also says that the accused person may. When it applies may, Mr. Chairman, it gives the accused person a discretion. What we understand now, Mr. Chairman, and members of the court, is that the accused person has chosen to exercise their right to raise an objection. We have not listened to the objection because according to the accused person in the law, he has asked his lawyer to make the objection. So, my lord, in that regard, we will be inclined, if we are to agree that we follow this procedure of this court, we are enjoined to listen so that the state may respond, and then the court will make a pronouncement. That is what, Mr. Chairman, we understand.
Of Aaron on the 10th for merely trying to get access to the court to represent the client. We feel as advocates intimidated, and we raised those issues before the court. I believe we were not satisfactorily answered, but the other issues we have raised, because we had to draw the attention of the court. We are not here by accident. The law provides. The Constitution, the UPDF Act, all provide for an accused person being represented by a lawyer of their choice. And therefore, we need access to the court without let or hindrance. Today, access was much better than earlier, but outside the court, most of the lawyers are having to walk long distances, being forced to park their cars away from the court. We raised that as an issue. We are yet to receive a satisfactory answer. Then it came to the issue of amendment of the charge sheet, which we were rejecting because we wanted the issue of jurisdiction dealt with first. They read, the court ruled that the charge sheet, they will allow the amended charge sheet. It was read. An accused person who is a serving military officer was joined in the charge. He pleaded not guilty. We advised our clients not to plead because they had objections. But they are also well versed enough to know that when they have issues, they should not plead. So Dr. Besigye spoke and said he wanted his lawyers to raise objection to the charges. We have raised objection to the charges, mainly on the manner in which they were brought from Kenya without any extradition order, without appearing before the court, without immigration procedures. We have also raised the issue of territorial jurisdiction. The Constitution of Uganda and the UPDF Act all point to territorial jurisdiction within Uganda. The UPDF Act appears to give jurisdiction outside, but we are arguing that jurisdiction is territorial because that's what the Constitution says. We are now waiting for a ruling tomorrow. The court has adjourned. The military has also, the prosecutor has given his replies. We are waiting for a ruling tomorrow on whether the courts in Uganda, including the General Court Martial, has jurisdiction on matters that happened in Kenya, in Athens, Greece, and also in Switzerland.
What can you say on the issue of Section 117, which talks about civilians being charged in this court? Because it is what they are raising, and Article 208.
We have raised, and it's for the court to rule, that there is nothing in the Constitution that confers upon the UPDF civil or criminal jurisdiction on Ugandans, and that their jurisdiction, especially civilians, their jurisdiction is limited to disciplinary offenses of military officers. Those are the issues the court will have to rule on tomorrow.
So all of a sudden, they come up with an ambush and bring up this gentleman and add him on the charge sheet. So of course they are up to mischief. These are all choreographed things intended to cause a mischief, as I've said. But we are also prepared to deal with the same. One thing I needed to emphasize on the question of extraterritorial jurisdiction. You see, they have attempted to bring a very old case from Tanzania. Let me tell you, for us, we have done enough research on this matter. The Commonwealth position is that you cannot abduct an individual and try them elsewhere. It's not possible, it's not allowed in law. So good, we have submitted to them a number of authorities from South Africa, how some actors in ANC had been abducted from Swaziland. We have submitted to them authorities from the House of Lords of England and a couple of other jurisdictions. So the position is very, very clear. It can only be through extradition. You cannot abduct an individual whom you have not even considered to be a criminal fugitive, a fugitive, and then you subject them to martial law. That is totally out of, outside the Constitution and also the practice within Commonwealth.
And so after being overruled by the court on the issue of counsel on fees and the clients are still behind the bars, what can you say over that? Because they say that someone who is convicted cannot represent anyone in court. What is your take on that? Is it all?
No, unfortunately, there is no decision, and we have issues with that because it's only the judge advocate who gave his opinion. And under the law, he's only an advisor. His opinion, he says, it's like any other opinion.
It cannot amount
it is like an assessor, actually. It can't amount to a ruling. So we are baffled by this practice here, where you find a judge advocate whose duty in law is just to give advice, but when he makes a decision, and he actually is proud of it, that his opinion is binding, is final. And he even had the audacity of telling us, whoever is not satisfied, you are free to seek for a reference. That shouldn't have come from him. That whoever is dissatisfied, he can can seek reference to the Constitutional Court to interpret the opinion of a judge advocate. We can't even do that. That we are going to the Constitutional Court to seek for the interpretation
of the court.
It can be of the court, fine. But the opinion of the judge advocate, which opinion he renders to the court martial. So we take exception to that, and there are issues. We are going to handle that legally, definitely. We are not going to take that lying down.
And Aaron Chiza is not sleeping on his rights. We know he'll be taking action. Watch the space.
Zisooseweza okulaba nti balooya batiisibwa okuva lwe baakwata Aaron Chiza ne bamusingisa emisango egya contempt of court, ne bamutwala ne bamusiba myezi 9 nga kimenya mateeka, kubanga ennaku ezoogerebwako ziba 30. ate n'embeera ekyali mu kooti wano nga bw'ogiraba bwefaanana kulaba nti balooya bagamba paakinga eri wala mujje nga mutambula n'ebitabo byammwe mujje nga mukola kino okutiisibwatiisibwa. Omulabye chairman wa kooti yennyini atuuse n'okugamba nti gwe Lukwago oli omu ku abo abagenda batiisatiisa kooti eno era tujja bakangavvula. Yagadde omubuuza nti ogenda tukangavvula mu nkangavvula ki? Asirisi aŋŋaanye okwogera nsitusawo nga njagala mubuuza mpulidde ng'ogamba nti tweweze nnyo okusuula kooti eno nti era ogenda kutukolako nga njagadde omubuuza nti mu nkolako efaanana etya tugitegeere egende ku rekodi naye ekintu ekyo n'atulemesa okiddamu. So embeera ekyagenda maaso ey'okwagala okututiisatiisa naye tetugenda kukkiriza
nti talina buyinza ku bannamagye
agambye ye talina buyinza bali ebweru eno n'abo ab'amagye abatalina nnamba abeekapisa ebintu ebitategereka maaso abeekapisa balinga bagenda ku mwezi n'ebintu ebifaanana byo. So tujja kusigala nga twebavumu okulwanyisa ebikolwa ebyo. Naye n'ekirala kyekyokuba nti baleeseeko omujaasi omuntu omulala mu mbeera etategeerekeka. Ebbanga lyonna tubadde wano nga boogera ku Obedi Lutale, Dr. Besigye babasanga ku Riverside n'amasasi n'emmundu episto nti FNZ simanya Dr. Besigye yali alamuza kino ayagala bayambeko ajja alumbe eggwanga compromising security nebyo byali simanya ne Switzerland teboogerangako nti waliyo omujaasi gwe yali naye nti yaliko naye mu meeting kale oba yali naye lwaki ye tebamusitulirako ne bamuleeterako kwolwo kakati balina emipango gye baleeta. Waliwo ekkobaane ery'amaanyi eriri awo era eggwanga lirijja okutegeera mu maaso awo ebintu bijja byerambulula bulungi. Kati ekirala ekisembayo kye kyokuba nti tukyawakanya era tulemeddeko okukya jurisdiction ya kooti eno n'obuyinza bwa kooti eno okuwozesa emisango gye bagamba nti gyajjizibwa bweru wa Uganda. Ekyo kwegamba n'atali puliida akiraba nti kooti eya Uganda wano ya General Court Martial ebeera etya n'obuyinza obugamba nti gwe twakusanga n'ekissi oba pisto n'amasasi ku Riverside e Kenya kye bayita monopole ya UPDF nti pisto esangiddwa ne Dr. Besigye nga bwe bagamba e Kenya munayo monopole ya UPDF. Kigamba ekyo n'atali looyo okiraba ne bagamba nti kyekyo kye kibawo obuyinza okumuwozesa. Ekyokubiri kwe kidnap tubalaze amateeka nga bwe gali. Si Uganda yokka yeesooseeyo. Ensi nnyingi South Africa eyo abantu ba ANC baagezangako bawamba mu nsi gye baddukiranga. Naye kooti etaputa ssemateeka eya South Africa n'ekirambika bulungi mu misango mingi ng'eraga nti abantu abo abaawambibwanga kuva Swaziland kuva luddawa ne baleetebwa batwayingirwe South Africa kyalinga kimenya mateeka era ng'emisango egyo egisazaamu. Ekyo nga kiva ku misango ne Bungereza gye twajja amateeka gano aga Commonwealth nayo yagamba nti nedda omuntu yenna gwe bagamba nti bamusanze mu nsi ndala ne batayita mu mateeka matuufu omuntu oyo bayina aba bamuleese mu bukyamu. Kaakati e Uganda tulina etteeka erya 1964 Extradition Act lye lirimu enkola mw'oyita okuzza omuntu yenna gw'ogamba nti alina emisango e Uganda. Tujja enviiri ku mutwe wano ngaga nti Uganda erina endagaano. Waliwo endagaano eyakolebwa wakati wa Uganda ne Kenya. Bw'obeera e Kenya ne balowooza nti oli muzzi wa misango e Uganda balina engeri ey'ekimpukumpuku gye basobola okuyisaamu ne bakukomyawo. Era ekyo tekirina tubabuuziza endagaano eyo yakolebwa mu tteeka kinga Matama Ntengo nsonyi okozesa ekigambo ekinene. Ye endagaano eyo eriwa nga bonna tewali anyega. Kakati katulinde kye bagenda okusalawo. Ddala bagambe nti Uganda erina endagaano emenya Extradition Act nti tulina endagaano ne Kenya egamba nti osobola okukidnappinga omuntu e Kenya n'omukomyawo wano nga tayise na mu immigration tayise mu mateeka gonna tulinze tulabe ddala oba General Court Martial egenda kugamba ekintu ekyo nti kiri mu mateeka okubeera n'endagaano ne okuwamba omuntu n'omuleeta ate nga n'endagaano eyo yini gye boogerako yakolebwa ddi ani yagissaako omukono byonna tebabyogera. Extradition Act eyo eri bulungi nnyo. Etteeka eryo erya extradition ligamba nti bw'aba ali Kenya minisita w'eno yasaba era alina kuba criminal fugitive ng'ali eri minisita oweri naye n'agamba nti okay kale katubitwale mu court magistrate court nefulumya court order egamba nti oyo mumuzeeyo e Uganda. Kiri mu giraasi nti ebyo byonna tebyakolebwa.
Omusumba ye n'asaba n'agamba bagawugule gagende wakufuluma
Era mbyagalira ddala pulezidenti wange
be twasaba bajje batusabire tebakoze eki tebalabise
tugenda kwekalakasa paka eza paka bulya